Okay, continuing here in Chapter 3, Week 3 material. We're on slide number 22 of the PowerPoint, talking about another case that's important to know as it pertains to federalism and power basically moving to the national level. That's a case called Gibbons versus Ogden, okay? And basically this was a case where New York had a ferry company, okay? And basically it granted a monopoly on a ferry, but the problem is that ferry company operated over to Jersey, right? If you know anything about Jersey, you got a quarter for a cup of coffee, right? You think Jersey. And so Jersey resident is like, hey, I got a problem with that. You know what I'm saying? You can't grant a monopoly on a company from New York, okay? We're from Jersey, okay? So in other words, the issue was, you know, can states grant monopolies to companies? Because again, what New York says is not recognized by New Jersey. Can you see the potential for conflict there? Okay, so it went over to the Supreme Court. Okay, and you know, because the issue at hand is the Constitution says in Article 1 that Congress has been granted authority to regulate interstate commerce, okay? In the case of this ferry company with a river connecting Jersey and New York, right? That's a great definition of interstate commerce, okay? And so when Justice Marshall took the case, he asserted that the legitimate uses of national power took precedence over state authority and that the necessary and proper clause and the Commerce Clause were broad grants of national power. Okay, Justice Marshall was a nationalist, so he was seeking, and he was also a federalist. Okay, so he was seeking to basically give more and more power to the national government. Okay, and so Marshall provided the United States government with the legal justification for expanding its powers in ways that fostered the development of the United States as a nation rather than a collection of states. So the holding of Gibbons versus Ogden, again, was national law trumps state law, okay? Because again, if, you know, what if the state of Illinois granted Apple monopoly status on its phones, and so Apple tried to sell its product in Michigan thinking that they've got a monopoly, when Michigan's going, hey, we didn't grant a monopoly to, you know, iPhones here. You know, we've got, you know, all kinds of other phones that we're selling here. You know, you could see where that could be a problem here. So that's where, again, Marshall was correct in his decision, because if not, you'd have all kinds of conflict. Imagine, you know, being granted a monopoly to sell in one state and you can't sell in another state. And so the ability of Congress to regulate commerce among the states was important there. Okay. So let's go to the next case. Okay, this is a reversal. Okay, McCulloch versus Maryland and Gibbons versus Ogden were cases in which national law trumps state law, okay? If you move forward to 1857 and the case of Dred Scott versus Sanford, okay, this involved a slave that escaped an owner and was seeking to enjoy constitutional protection, and it went before the Supreme Court. In this particular case, in Dred Scott versus Sanford, state law trumped national law, okay, which was, and again, this case we're going to talk about right now, Dred Scott is considered probably the most controversial and probably worst decision of the Supreme Court's history, okay? And so, you know, as we're talking about slavery in America in the 1830s, 1840s, 1850s, there was a movement within the southern states, okay, to justify slavery, besides just the economic advantages they were seeking to make. But I think we talked about this in chapter 2 a little bit about historicism and Hegel, okay, a German philosopher who advocated something called historicism that influenced the progressives in America in the 20th century. But essentially the argument of historicism is this: newest is truest, latest is greatest, okay? So that thinking is later epochs or later times in history are more legitimate or more real or more rational or more true than previous eras of history, okay? So the most real is the most rational and is the most current, okay? Newest is truest, latest is greatest, okay? So there was an individual called John C. Calhoun, okay, who was a Southern politician. And he began to argue, drawing upon Hegel, drawing upon newest is truest, latest is greatest, is that slavery is a positive good, okay? And his thinking was that because slavery is here, because slavery is practiced, if it's really true that the real is the rational and the rational is the real, if it's really true that newest is truest and latest is greatest, because we currently have slavery, slavery is a good thing because it's here. In other words, if it wasn't here, it wouldn't be true. Okay, hear me. The logic is kind of wacky. Okay, but that interestingly, that same logic has been used to foster homosexual rights in the present era. Okay, but anyway, but it's just kind of it's really interesting. But he began to justify the expansion of slavery, and he began to say that the United States was founded on a compact between the states, and that the national government is a government of states, not a government of individuals. And so he began to say, listen, let the states decide slavery, not the national government. Let the individual states decide whatever they want to decide, state from state. That's what's legit. There should be no one size fits all. Let the states decide. And Calhoun began to advocate a legal doctrine called nullification, the idea that a state has a constitutional right to nullify a national law. So in 1832, South Carolina invoked this doctrine, and they declared null and void a national tariff law that favored northern states. Okay, Congress actually began to amend the law, but this idea, Calhoun's idea was states can nullify a national law. So then, okay, so again, just follow with me the history. So fast forward to 1857, okay? Dred Scott versus Sanford. The case was such that Dred Scott was a slave that escaped, okay? He escaped from the South, lived in the North for 4 years, and he cited as his justification, because they wanted to take him back and make him a slave again, the Missouri Compromise of 1820. What was the Missouri Compromise of 1820? For every new territory that was admitted to the Union after 1820, okay, if a slave state was admitted, then the next state to be admitted had to be a free state. And then after the free state was admitted, then the next state should be a slave state, okay, and so on and so forth and so on and so forth. And so because Dred Scott lived in a northern state that was a free state admitted, he said, listen, Missouri Compromise of 1820, I'm free. I don't have to be sent back and to be put back into slavery, okay? The Supreme Court ruled against Scott, claiming that slaves were not citizens and therefore had no right to have their case heard in federal court. The court also invalidated the Missouri Compromise by holding that slaves were property, not people. Okay, again, remember, this is the first time that judicial review was used by the court since Marbury versus Madison. So since the Constitution prohibited Congress from interfering with owners' property rights, and slaves were considered property, slaves could not outlaw slavery in any part of the United States. And so what the court did in it was a terrible decision on a multitude of levels, okay? The main one is that they said that slaves were not people and not granted constitutional protection. That's number one. Number two, they basically engaged in judicial review and struck down an act of Congress, and they began to say that states were currently free states should suddenly now allow slavery. Okay, in other words, there was this. It was a comedy of errors. Okay, but the net effect of Dred Scott versus Sanford, not just condoning slavery, but basically said that states can nullify national law. Okay, so it contributed greatly to the Civil War, because again, if you've got states in the South condoning slavery, suddenly now looking to the federal government saying, we're not listening to you, we're going to start nullifying everything you say, how can you keep a union together? Okay, you can't. And so historians will tell you that the Dred Scott decision contributed directly to the Civil War. Okay, in 1860, the Democratic Party split because of the Dred Scott decision, and it actually led to Abraham Lincoln's election. Okay, had Dred Scott not occurred, most likely Abraham Lincoln would not have been president. Okay, and so the civil, in other words, if you've ever wondered, okay, I don't like the Supreme Court decision, what can undo a Supreme Court decision? One way you can undo a Supreme Court decision is the nation can have a civil war. That's how you can override a Supreme Court decision. And that's exactly what happened with the Civil War. Okay, the Civil War actually decided that, au contraire, Dred Scott versus Sanford, national authority is binding on the states. Okay, so hopefully you kind of understood that. I know there's a lot of history behind it. Again, I'm just trying to give you the background. The main thing you need to realize is the three holdings of these Supreme Court decisions. Okay, McCulloch versus Maryland, national law trumps state law. Okay, Gibbons versus Ogden, national law trumps state law. Dred Scott versus Sanford, state law can trump national law. Okay, so just kind of remember those. Any questions, again, shoot me an email, reach out to me. I'll be happy to help you. Okay, I'm going to stop there.